Legal gymnastics now that we interposed by filing this petition. Instead, this is a legitimate attempt on the part of the people in order to stop a constitutionally void as well as defective, procedurally defective and jurisdictionally deficient impeachment complaint that was filed against VP Sara Duterte. No, we would like to emphasize that this is our individual move, collective efforts on the part of us individual petitioners, and VP Sara has nothing to do with this. And this is our move because we feel that the impeachment complaint really is defective based on three grounds, three principal grounds. Number one, there were three impeachment complaints that were filed on December 2, December 4, as well as December 19 by different individuals. Well, you can say that they are mostly on the left, but the fact remains that there were three, impeachment complaints on December 2, 4, and 19. December 4 complaint was the second complaint, and the endorsement, it was filed by Attorney Nery Colmenares et al. And endorsed by Representative Franz Castro and two others. And why do I have to emphasize this? Because they are the ones now belittling our moves. And why is this important? This is important because if you base it under Article 11, Section 3, Paragraph 2, okay, you will realize that it is mandatory under the 1987 Constitution for the House of Representatives to act right away on any impeachment complaints and accordingly subject it to the order of business within 10 session days and refer it to the proper committee within 3 session days thereafter. Now, if you will likewise read Rule 2 of the, House of Representatives on impeachment, it is likewise clearly stated therein that upon receipt of the impeachment complaint, it should be referred to the Speaker by the Secretary General, and the Speaker is mandated by their own rules to have it set in the order of business within 10 session days from receipt, and the Speaker is mandated by their own rules to refer it to the Committee on Justice within 3 days. And what did they do? They never acted on the three complaints. And these were filed on December 2, 4, and 9. Never acted. They waited until February 5, no? On the last day of the third House session, third, and what did they do? They fast track. No, we can even characterize it, to borrow the words of Justice Corona, blitzkrieg fashion, the filing of the fourth impeachment complaint, and in just 3 hours, more or less, 215 congressmen allegedly read and verified the thick impeachment complaint that was the fourth one that was already filed. Which brings me to another ground, therefore. No? Why do we say that this is constitutionally deficient, defective? Why? Because Article 11, Section 3 mandates, in relation with the House Rules of Procedure on Impeachment, that the said complaint should have been referred in the order of business within 10 days and referred to the proper House committee, and in this case, Committee on Justice within 3 session days. They never did that. Why they did not do it? They did not do it in order that Francisco versus House of Representatives would not operate. And warning the impeachment of then Justice Davide. And in that case, the Supreme Court ruled that Article 11, Section 5, Paragraph 4, the 1-year bar rule, shall operate at the time when the impeachment complaint shall have been referred to the Committee on Justice. So if they referred the complaint, any of the three, to the Committee on Justice, then the one-year bar rule would have operated, and therefore the fourth complaint would have no basis at all. And that is very clear. And the mandate on the part of the House of Representatives to act on the first three complaints is not a matter of discretion. It should have been done. But they never did that. They dilly-dallied and they waited for the fourth complaint at the last hour before they entertained, in a flash, in a blitzkrieg fashion, this fourth complaint. So if you will base it on Francisco versus House of Representatives, Gutierrez versus House of Representatives, the fourth complaint would have no legal basis anymore. Okay? Second point, the verification requirement. If you will read Article 11 of Section 3 of the 1987 Constitution, if they base it on Section 5, that if they have the one-third vote of the House of Representatives, please read it in the 1987 Constitution, that in case the verified complaint, so meaning, before you talk about trial in the Senate forthwith, you must see to it that there was proper verification, because the law Constitution requires in case of verified complaint. So we must determine, therefore, as to whether or not there was proper verification that was conducted in vis-a-vis the impeachment complaint as submitted and filed in the Senate. If you will look, this can already been revealed now. If you will look at the impeachment complaint as filed in the Senate, there was even no proper verification.